Right.
All right. Hello, everyone. Welcome to the HodlCast. And today we're very lucky to have compliance ninja and one of the foremost experts in the compliance space, Amber Scott. And Amber, thank you so much for coming on. And we had you last year when we were at Crypto Springs and we were talking about FinCEN. And this year we're going to talk about the Financial Action Task Force. So Amber, if you could maybe just give a little background on yourself, how you got involved in Bitcoin, and what you're doing now, one of the lady CEOs of Outlier Solutions, and maybe talk a little bit about what you do there.
Sure. So I'm a compliance geek. What Outlier does is help people meet their compliance obligations. So we say a little bit tongue-in-cheek, but not entirely jokingly, that our job is to try to keep our clients out of trouble. And I got involved in Bitcoin in 2013 by accident, not because I was prescient in any way or understood how amazing it was going to be, but because a really good friend of mine who was doing payment processing called me and asked me if I could help them to update their risk assessment because they were doing a lot of processing for a Bitcoin exchange. And I said, sure, I can do that. I have never transacted in Bitcoin. So at the time I had read about it in Wired, I was aware of it on this kind of like very cerebral, not real level. And for me to really do, to my mind, a solid risk assessment, for me to understand how things work, I have to play with it. So I asked if they could pay the retainer in Bitcoin because I needed to get my hands on it. I needed to transact. I needed to understand. And he said, sure, I'm going to send you a couple of articles. This is a Thursday. I need you to read them. I need you to download a wallet. I need you to secure a wallet. I cannot help you whatsoever with the security of your own wallet. That's something that you need to be able to do because, of course, you shouldn't be giving your secrets to anyone, and those really are very private things. And so on Monday, after I had started to fall down the rabbit hole and just do a ton of reading about these things, he called me and said, okay, like, do you have a wallet? Are you ready? And I said, no, I don't think at all. But I do have a wallet and now a rudimentary understanding of security, and let's do this. So it's been a learning experience since then, and still is.
Mm-hmm. Yeah, it's one of those spaces I find where there's always something new happening. Like no matter how long you've been in it, there's constant involvement, I guess. And
so I don't know this about you, by the way. Can I ask you the same question? Like, what was your first Bitcoin sort of involvement transaction?
Yeah, so there was a portfolio manager at my old company. I used to work in Canada with NEI Investments that does a lot of socially responsible investing. And we had a portfolio manager, Christine Hughes of Otterwood Capital, and she was really into macroeconomics, and she would give these great updates, but she would always include the price of Bitcoin on it. So I saw it go from $2 to like $11 to $200 without getting into it, wondering all the time how to buy it. And I joined a couple meetups in Halifax, and I never attended them. And then I moved to Jacksonville in 2014 for law school. And when I got here, I was having a lot of trouble moving money from my Canadian. I had a Bank of Montreal account, and then I had a Bank of America account here. And now I know, a little plug for TD, they have great cross-border banking, but at the moment I thought, well, maybe if I could use Bitcoin, I could convert it from BMO, bring it over, and then put it back in B of A. But that was not, the infrastructure was not there yet for converting it. But in the process, I started listening to a ton of podcasts. I was painting my new apartment and just listening to Andreas Antonopoulos on a few different, I think he had already had 2 Joe Rogan podcasts. And then I just decided to put up a little employment ad to see if I could get some part-time work in the Bitcoin space. I thought, same as you, I really, just hearing about it I had heard about it for 2 years and not done anything. So I thought I need to take an action step here. So I ended up off the Upwork website getting a job as a compliance officer for a Bitcoin ATM company. And I didn't have full understanding of what that really entailed. And the company was just forming, and we kind of worked through a lot of the issues together. And then we brought on some, there were some other employees. Their attorney came on with us, Adela. And it was really interesting learning how to navigate the FinCEN registration, and secondly, how to handle the cash management of it. We couldn't find anyone to go pick up the cash at the ATMs or insurance or the state-by-state licensing. We had Perkins and Coie at $1,800 an hour. That's what they were charging at the time, to give us a list of what states were, they had the yellow and the red and the green. And so yeah, that kind of got me involved, and then I started going to a few conferences and fell in love with it ever since. Yeah.
Awesome. So you were probably one of the early compliance officers in the Bitcoin space then.
Well, I actually met Andreas at a conference not long after that, in Orlando. It was called Coins in the Kingdom. And when I said that my title was compliance officer, he actually pulled me aside and really was quite frank about all the risks of putting myself in that role. And I kind of stepped back from it. So I didn't keep the compliance officer title for very long, because I was quite busy with school at the time too. So I was, you really need to be dedicated full time to do that. And the compliance officer is the one that I think, a lot of the risk falls on. So kudos to you for taking it on for people. Mm-hmm. Yeah.
We do what we can.
Yeah. So today, I guess we're going to talk about the Financial Action Task Force, and you've been busy giving presentations on this all over the place. So I'm really glad to get your insight on it. First, I guess maybe could we give everyone just a general background of who the FATF is?
Sure. So the FATF is the Financial Action Task Force, and they're an intergovernmental body. So what they do is they issue policy. They issue policy with regards to anti-money laundering and counter-terrorist financing. Their member countries then go and translate that into law. So their policy that the FATF issues is very influential in shaping laws that are put out by different countries. But I think that's a really important distinction, in that the FATF is not a regulator. They're not a lawmaker. The guidance that they issue, the policy that they issue, is non-binding. And so there's not a legal obligation, so to speak, for countries to follow it. They are, however, very influential, in that countries that are members of the FATF, which is most of the developed world in some capacity, will actually do what's called a mutual evaluation. And that's like an audit, where they're looking at one another and saying, okay, how close is your system to actually following the FATF's recommendations, and where are you offside from the FATF's recommendations? And where a country is seen as being particularly non-compliant, that can lead to issues with trade, and that country being branded as high risk from an anti-money laundering or counter-terrorist financing perspective, which can also lead to sanctions and other things. So it can be really problematic to be offside, even though it's non-binding.
Mm-hmm. And what are their main objectives in terms of when they're crafting the regulations?
For when the FATF is crafting their guidance, or when countries are crafting
guidance. Like what is their main purpose?
So really to have things that are going to be effective, things that are going to be good guidance for countries in terms of combating money laundering and terrorist financing. They really want to highlight what are emerging as different risks. So things that they're seeing in terms of emerging risk, and that's, I think, where the emphasis on virtual assets came from. They're seeing these asset classes that are growing, that could potentially be used in nefarious ways, but that are also becoming much more commonplace, that people are using in just everyday uses. Much like we would use the banking system or money service businesses. So when you have something that's developing on that scale, then you have to think about what the risks are and what types of regulation should be in place.
Sure. Mm-hmm. And what are the countries who are members?
So I don't know them all offhand.
Pretty big list.
Yeah, it's a really long list. So I think there are 38 or 39 that are core member countries. That would include Canada, the US, most of Western Europe, a good part of Asia, a good part of South America, Australia, some of Africa. There are also some other organizations that they're affiliated with. So there's the FATF, which is like the Caribbean FATF, which is an organization specifically related to the Caribbean countries, as well as a number of other affiliated organizations.
So it's pretty wide-reaching, these recommendations that they've put forward.
Yeah, absolutely. If a country is a stable country with a stable government, they are probably a member in some capacity.
Mm-hmm. And I guess, with terrorism, it does cross, all borders. So it makes sense if that is their, the goal is to catch and stop terrorist and money laundering. They need to work together for it. So they came up with a few, well, they weren't actually, I don't think they were, I heard these acronyms when they put out something about 6 months ago, but they started referring to VA and VASPs. Can you give us a little overview of what those mean?
Sure. So virtual assets and virtual asset service providers. So virtual assets, they went really broad on that one. So they're talking about cryptocurrencies. They're talking about things that may or may not be securities. Really anything that's tradable. So they're looking for things that are virtual assets, whether they're centralized or decentralized, they would still be in scope. They're looking at things that are tradable, things that have markets. And so the intent really isn't to capture things that are closed loop. So if you're talking about something that isn't exchangeable, that isn't tradable, and some of the examples that they gave were things like airline miles, or credit card rewards, or loyalty programs. Those were not meant to be captured. I think that there's a lot of funny nuance because we do have secondary markets. So there were some interesting commentaries that they made about things that might or might not be virtual assets. And some of those were things like gaming tokens. Now, I don't think the intent there is to go after people's World of Warcraft gold.
Yeah.
Yeah, like I don't really think that's it. But I think there is an acknowledgement that in certain capacities, some of these gaming tokens do actually have significant secondary markets. And I think we have a couple of cases working their way through various systems right now where those have been used in money laundering cases.
Oh, okay. Mm-hmm.
I think that those ones are, from a case law perspective, they're going to be interesting. I probably don't think that it's a fantastic way to launder money overall. If I'm thinking about money laundering schemes, and part of that is just the vast amount of information that you're putting into any one of those platforms in order to be a participant.
Mm-hmm. Yeah, it would all be hooked up to the banking system, typically, I believe, when you, or can you buy just straight gift cards for the games, maybe?
I think that's part of it. It gets pretty onerous when you're doing it. If you were to do it that way. So if you were to buy gift cards, which are generally smaller denominations, and then try to stack a bunch of those to buy game tokens and then cash out those game tokens, it's not a very efficient way of laundering money. Theoretically, it can be done. But really to be efficient, you need a connection to the fiat money system.
Right. Mm-hmm. And then the other one, the VASP.
So virtual asset service providers. Really here what they're talking about is businesses that do certain activities on behalf of their customers. And there was a lot of confusion about this because when they talk about the VASP, they talk about individuals, they talk about entities, and all they mean by that is it doesn't matter if you've incorporated a company or formed a partnership or a trust. If it's a thing that you're doing for business purposes, then you're covered. So it's covering the idea that maybe instead of forming Outlier Solutions, Inc., I decided to just be Amber Scott Consulting, and I would just be a sole proprietor. And if I had done it that way, and I was providing virtual asset services, then I would still be covered. And the services that they're looking at are exchange, so exchange between fiat currency and virtual assets, and then exchange between virtual assets. And that's really different from what they talked about a few years ago. Mm-hmm. So in their initial guidance, they really talked about what they called on-off ramps. So those were exchanges between fiat and virtual assets. But I think it's important to consider that in 2014, no one had raised millions of dollars for an ICO where they only took in Bitcoin or Ether. It's a very different world now than it was at the time that they wrote their initial guidance. One of the other things that wasn't there when they did the initial guidance was stablecoins. And stablecoins aren't fiat. They're not issued by any government, which is part of the prerequisite for being a fiat currency. They're really a virtual asset that's pegged to a fiat currency. And at the point where they started talking about on-off ramps, we didn't really have stablecoins, and they weren't, if there were, they weren't prevalent in the way that they are now. And so those are, I think, two big differences that really led to a move away from the idea that we're just talking about on-off ramps, and we need to look at the exchange between virtual assets themselves. They talk about the transfer of virtual assets, and it's really important there that we're not talking about just as an individual. When I send you Bitcoin, that's a peer-to-peer transaction, and that's not what they're talking about. They're not talking about the networks overall, but they're talking about when you have an intermediate transaction that's happening with exchanges, with hosted wallets in a situation where you don't have custody over your own virtual assets. They're also looking at escrow services, so that's one of the things they talked about potentially being in scope. And potentially escrow services that could include just smart contract executed escrow services. So I think there's going to be some really interesting nuance there in terms of how that plays out with the laws in different countries. And they talk about ICOs as well. So ICOs, STOs, IEOs, whatever the terminology is. I actually had kind of a laugh out loud moment when I was reading through it, because one of the things that they had said in their guidance was that it doesn't matter what you call something. So they were saying there are some terms that may lack a common understanding across jurisdictions, including within the industry, and they used utility tokens as an example of that, which is to say that it doesn't matter if you're calling it a utility token. If it's a security, it's a security. If it's, regardless of how you choose to name it, if it's a virtual asset, then the intent is that it should be regulated by the jurisdictions that a business is operating in.
Mm-hmm. Yeah, and you brought up two big points there, the custody issue and I think the escrow issue too, because they've been coming out in America with, FinCEN had that recent guidance. I think it was actually in April where they outlined everything for the money transmitters or who needs to register with FinCEN, and that custody was a really big turning point of whether or not someone has to register. And it appears the Financial Action Task Force also considers that in their views. So if you're not taking custody, you're not considered a service provider. Or would you agree with that? Or
I would agree with that. So if you never have custody of your customers' assets, then there's something else that you're doing. So when we have a lot of people that come to us and they say, well, we're just software, but then they've got custody and they're doing different things. And at that point, you stop being software. I can access my bank on an app on my phone, but just because I'm accessing it on an app doesn't mean that they're not my bank. They don't cease to be a bank based on my channel of access. And I think you have to take a similar model here, because that's really what our laws are based on. They're not written around virtual currency or virtual assets. They're really written around traditional financial services. And to my mind, if what you're doing is mirroring a traditional financial service and that you're being an intermediary or being a custodian, then you're probably covered under one of these laws.
Mm-hmm. And what are some of the bigger misconceptions you've heard since this guidance has come out?
I think some of the big ones are that the intent is to regulate technology, and there's call-outs within the documents themselves, so within the guidance from the FATF, to say that this is not intended to regulate technology, it's not intended to regulate networks, it's intended to regulate businesses doing specific business activities. Similarly, that it's intended to regulate individuals, so that there's going to be regulation that applies to peer-to-peer transactions. And that's not to say that it isn't possible that some country decides that they're going to put in regulation for transactions between individuals. But it's not something that I've seen up until this point, and it's certainly not something that's being recommended.
Mm-hmm. Except, I know you're in Canada, and I think it's a little different rules, but I know you're well aware of the American rules as well. But for the individual side, and I guess this might it might be the same in Canada too, but with local Bitcoins, there's been a lot of that's where it's causing some confusion of when someone turns from being their self, selling a little bit of Bitcoin, to a peer, to being in the business of selling Bitcoin. And I think some of the things that contribute to becoming in the business of and covered by these regulations are how you advertise yourself for it. If you're putting yourself out to the public as being someone that can provide this kind of liquidity services, or if you're charging a commission on it and things like that. So I think that's one area where people are getting, it's one that's come to me a lot of, oh, am I a money service business or am I an individual that's not covered by it? So
I think that one can get pretty nuanced. And I think there's a difference between me going out and advertising in the same way that there would be in the traditional money service business world. So if I'm coming to Florida next week and you're coming to Canada the month after, and you say, hey, can you, we know each other, can you bring me some Canadian dollars, and I'll give you some US dollars, and we'll just exchange between us. That's a peer-to-peer transaction. You can do that with fiat money, and it's okay. But if instead of just visiting you and us exchanging money between people who know each other, if I put up an ad that said, hey, I'm going to Florida next week and I need some US dollars, then you get into different territory. And I don't think that there's always a clear line in terms of, where does it get crossed? Where does it become a business? In some areas of our law, we have de minimis exceptions. So both in Canada and the US, there are some de minimis exemptions around jewelers and dealers in precious metals and stones, to say that, really, if you're never doing certain types of transactions or you're below a certain threshold, then you're not covered. But we don't have that for money service businesses. I don't think on either side of the border, and correct me if I'm wrong about the US.
Yeah, no, not that I'm aware of anyway.
Yeah, so I think there's always a risk there. And if someone wanted to be, in my opinion, if someone wanted to be really sure that they were never captured, part of that, I would say the most conservative approach would be always going through an exchange, and specifically an exchange that was either registered as a money service business in Canada, licensed as a money transfer organization in the US. So you're always the client of that registered business. And I think that's probably the strongest level of protection that you can have if you're concerned about your activity being perceived as business activity.
Right. Mm-hmm. And for the peer-to-peer too, it used to, the idea that I used to hear a lot, I kind of subscribe to as well, was, if you were doing a peer-to-peer transaction and someone said they were going to use the proceeds for illegal purposes, or they were giving you the money that was gained from an illegal purpose, then, you stop the transaction immediately and you wouldn't follow through with it. Otherwise, you would be violating some, the anti-money laundering regulations. But now it seems it's gone beyond that, so that even if you're just holding yourself out as a business and doing a transaction where you have no knowledge of either, any funds being used for nefarious activity, you still, if you're holding yourself out as a business and doing the transaction, then that's when you have to register as a money service business. But if you're out there doing it and someone says, oh, anything about illegal money, you can probably guarantee they might be, not guarantee, but there's a high probability it's an undercover officer trying to bait you into the
So this is really different in Canada and in the US, which I think is really fascinating. In the US, there's actually a lot of operations that happen where it is an undercover officer that that's specifically looking for someone to sell them crypto or to sell crypto to. where they're making it pretty clear that they're doing something nefarious. From a Canadian perspective, and what I generally tell people is, especially if you feel in danger. So I do know someone that got into a situation where they were selling on local Bitcoins. They showed up to meet the person. They weren't worried that the person was going to rip them off, but it was really clear that this person was armed and that he had bodyguards that were armed. Like, he saw butts of guns and, in trousers and things. And he did the transaction, left, immediately called me and was like, what do I do? I said, well, okay, so write down all the details that you can remember. Even if you're not a business, you can still submit, in the Canadian context, what's called a voluntary information report to the regulator, where you're just saying, like, this happened. And as part of that report, there needs to be, and I was afraid for my life. And so even though I knew that there was probably something nefarious that was happening, I did not want to refuse the transaction, because none of these laws should ever compel you to put yourself in harm's way. Right? Like anti-money laundering laws are here to try to prevent, detect, and deter anti-money laundering and terrorist financing. But generally speaking, you shouldn't risk taking a bullet because you might be slightly offside with something that's happening. So I don't know if you would say the same thing from a US perspective, but I would definitely say if you feel like you're in danger in that situation, complete the transaction as you normally would, and then report it as being a suspicious transaction. Write down all of the detail that you can about it as soon as you leave that interaction, but certainly don't put yourself in harm's way.
I think your advice originally was pretty sound, that if using the regulated services like Coinbase or things like that is probably the safest and easiest way to get your hands on some Bitcoin and not worry about any of, going outside of any of these laws or putting yourself in harm's way. And so I guess let's get into what are some of the regulations that the task force is actually recommending here.
So one of my favorites, and I think it dovetails nicely because we were just talking about criminality, but they have the idea that every business that is a virtual asset service provider, there needs to be some sort of licensing or registration. So basically these businesses would register as such. That's already the case in the US. We have a licensing regime or a registration regime that's coming into force in Canada in June of 2020. And some other countries have it in place already. And part of that is the idea that if someone is a known criminal or a known criminal associate, they would actually be barred from being, an owner, director, executive of one of these businesses. I'm a fan of that, generally speaking, and just the idea that if you're a convicted money launderer or a fraudster, or you've done some sort of financial crime, I don't actually ever want you running a business that custodies people's funds.
Yeah, I think we've seen where that gets us, with an exchange in Canada pretty recently.
Yeah, that it's unfortunate, but it reminds me in a sense, there's this old parable about a guy who, sees this snake and there's a flood and he carries the snake across a flooding river, and then at the end the snake bites him. And he's like, "Snake, I just saved you. Why did you bite me?" And the snake was like, "Dude, you knew I was a snake." And I think it's kind of the same with fraudsters, where, if someone's already defrauded people of money, like they've already made the decision that they're willing to steal from people. And so why would you put them in a position where they're now in charge of custodying other people's funds? Run a candy store. Do any other business. I don't care. Don't custody people's funds, and don't entrust fraudsters with custodying people's funds.
Yeah.
But that I think, from a prudential perspective, is probably my favorite of the FATF's recommendations, because I think that is going to do a lot, just in terms of starting to help legitimize businesses, giving businesses something to fall back on. One of the issues that a lot of businesses, both sides of the border, have had trouble with is getting bank accounts. So part of the recommendations that the FATF have made is that banks don't just wholesale consider all VASPs to be high risk. So VASPs consider the specific risk, consider their risk factors, don't just close all of their accounts wholesale, which I think was pretty fantastic because de-risking has been an issue. And I think for businesses to be able to say, we're registered, we're licensed, we have a compliance program in place, we're doing the things that we need to be doing, that will hopefully be helpful in opening up the banking sector a little bit for them.
Absolutely.
I think it's better in the US. It's been getting better much more quickly than it has here.
Mm-hmm. And one thing you brought up with the licensing, so would that apply also for initial coin offering issuers? I think it actually would, and I hadn't considered that yet myself. I haven't seen a lot of ICOs, coming forward these days. And in the FinCEN one, it's the guidance they gave there. It said if you are registered with the SEC, then you don't need to register as a money service business. You follow the SEC's rules, which also have bad actor checks, and if they're pretty strict with the same kind of guidelines there. But if someone was issuing a utility token or something outside of the SEC, it appears to me now that they would also be required to get this kind of license. So that would have, if that was in place in the ICO heyday, it probably would have eliminated a number of people. It seemed like all the fraudsters, moved, not all, but there was the space.
There were a lot.
Yeah, and if there had been something like this in place, it would have been a big detractor.
To me, some of the ICOs that came out that were really fraudulent or interesting, and if I had worked with those or if I was part of one of those schemes, I certainly wouldn't feel safe yet. Financial investigations take years to carry out.
Mm-hmm.
And I hope that we see a few more of them that were pretty clearly, there was some malfeasance there. I hope that we see those ones see some justice.
Mm-hmm.
I think it was hard. So many of them emerged around the same time. And Zach from Paycase made this comment once that's always really stuck with me. It's like sometimes the only difference between a fraud and just a business that failed is in the heart of the founder. And it's hard to tell that. Was this just a bad idea? Was this just someone starry-eyed that thought that they could execute on the promise of a technology that didn't exist? Or was this a deliberate attempt to bilk people of their money and buy Lambos? And it's not always clear.
Yeah, very true.
What
about the KYC requirements? Can you talk about that? So if they require the license, or what were the recommendations around how much, right now, what is I guess every country has a different minimum requirement for when information about who the customer is has to be collected. But I think there was a recommendation that, actually, the recommendations better. Was there one that said there's a minimum for the KYC, or?
They did. So they recommended a de minimis exemption of either $1,000, so US or Euro,
Okay.
As being the de minimis exemption. And the intent there is really to allow small transactions to take place without adding a tremendous burden. But I think that each country is going to come up with what their own exemptions will look like. From a Canadian perspective, we did stick with $1,000. So from our perspective, it's $1,000 Canadian or the equivalent, where identification and KYC information collection is going to be required.
Okay. Well, that'll help the IRS or whatever, countries, each respective tax collection agency probably is glad to see this in place as well.
Mm-hmm. One of the recommendations that comes with that I think is really interesting is the travel rule.
Yes.
And so they talk about information traveling at the time that there's a transaction between VASPs. So really, again, the intent is not I send you Bitcoin, peer-to-peer transaction capture. But when you have one VASP to another, that information would travel with it the same way it does with a wire. So if I sent you a wire, they would know that it came from Amber's bank in Canada, that it went to Sasha's bank in the US. You would know the bank's information. Each of the banks would know our information on a pretty detailed level. And that's what they're looking for to happen. And the really fascinating thing to me is how different the rails are with virtual assets. And one of the things when I read it that struck me was I was very glad that they didn't talk about the information having to travel with the payment. So they were talking about the information can travel separately. It can go through a separate system. They had a whole laundry list of different potential systems that could be used for this purpose.
Now, so, the old way of looking at this is the on and off ramps, but, this is also including any transfer of one cryptocurrency to another. So would this mean an exchange where a person goes on and, sells Bitcoin and buys Monero? Does the exchange who would the exchange need to send that information to, or would that be captured, or would it only be when they're moving off of one exchange to another exchange?
So the travel rule would only really apply to moving from one exchange to another, but the KYC would come into play with a single exchange. So if I had sent my exchange $1,000 worth of Bitcoin and then I was trading for Monero, then my KYC information, the recommendation is that it be captured. So I'd be identified, my KYC information be captured. Now the interesting thing is when it comes time and I say, okay, so now I want to take my Monero off exchange, one of the really interesting challenges, which isn't a compliance challenge, it's more of a technical challenge, is how do you know where that Monero is going? And so how do you know if I'm sending it to my own private wallet versus if I'm sending it to another exchange or to another custodian?
Mm-hmm. And then if it is to your private wallet, they can't, it's pretty difficult.
The travel rule stops applying at that point. It's just a transaction that I'm sending to myself. There's no intermediary there.
So the real goal of this is to prevent money laundering, but it really is not able to capture cryptocurrency at its core when people are using, cold storage wallets, because you could send it off an exchange to an unknown wallet that could belong to anyone. So all these efforts, it's not going to, I guess that's kind of the nature of cryptocurrency, but it is at some level you can see the transactions happening, but the identity is difficult if people do it without custody providers, if they're holding their own keys.
Exactly. There's the beauty and the pain point in having something that's going to be censorship resistant and that's going to exist in a way that is peer-to-peer, which I think are really important characteristics. I think the technical challenge for the exchanges who are compliant is really going to be how do they identify the addresses that belong to them? So how do they flag and signal that to other exchanges, and then how do they exchange that information between themselves in a way that's going to be secure, in a way that's going to make sense, and in a way that's going to be worldwide? Because really, you're not just talking about exchanges in Canada or exchanges in the US. You're talking about a pretty big international collaboration in order to get a system in place that's going to work.
Mm-hmm. Is there a way to so I know there was, my technical knowledge might be embarrassing right now if I say the wrong thing, but I remember Charlie Shin in the Winklevoss lawsuit a few months ago that ended up settling out of court. But the reason that was brought up was he had made a Vanity wallet where it was named his last name. So I wonder if exchanges could make the same kind of Vanity wallet where they have Coinbase Dash and then the number, or some kind of, they could put in some kind of identifier. It would be a giant workload for someone to go do it. There's probably a lot of room for error with having a manual person going in and messing around with the numbers of the accounts. That's probably more of a risk than, you know, what the possible reward of being able to comply with the travel rule. But that might be what would be needed for it to be able to know whose exchanges, you know, what coins came from where.
Yeah, and I don't know that the thing that wins is necessarily going to be an on-chain solution. So there's a fair bit that you could do even with putting a code or a message attached to your transactions. So you could have something sort of similar to your bank information codes, where it was saying if it was sent from Coinbase, this is always going to be part of the outgoing message.
Mm-hmm.
That's manual. It's pretty easy to forget that. You know, someone can run a script to make sure that it happens, but at some point it might not happen. I think that there's probably a pretty big danger that's twofold in terms of vanity addresses. And I would say the first part of that is that it's really expensive to make them. So, and anyone that I know that's made, like Andreas had made one, and like Charlie had done one, and I was back in the day where Bitcoin was not $10,000, and the, you know, the cost and amount of effort to do that was much less than it is now. If you're Coinbase and you're going to make Coinbase addresses, you want to make sure that before you give me my unique Coinbase address for my Coinbase transactions, that you're going to make more profit from me than the cost of that address.
Mm-hmm.
And I don't know, just from having worked with exchanges, that you get a lot of customers that are just going to sign up. You know, and customers that might do 1 or 2 transactions, and you have customers that do a ton of transactions. But for your customers who are just going to do 1 or 2 transactions, it's probably not worth it to create a special vanity address just for them. And then for your customers that are going to do a ton of transactions, they probably have some valid security concerns around just a constant reuse of that particular address. Beyond that, I think if there's a pattern, so if all Coinbase addresses start with Coinbase, and it's worth it for a fraudster to make a fake Coinbase address that seems like it's a real Coinbase address, so that they can get on Twitter and run their, hey, we're giving away free this, just send one, you know, ETH or like 0.1 Bitcoin or whatever, and we'll send you back 10. Mm-hmm. And people fall for those types of scams, right? If people weren't falling for them, they'd stop doing them. But if the value of running that type of scam is worth it, then there will definitely be fraudsters trying that. And that's hard, because even if you have a vanity address that wasn't created by Coinbase, you'll have people that are still constantly contacting their support to say, hey, we sent to this address that turned out to be a scam. How will you help us? Mm-hmm. Will you pay us back? What happens now? So I think probably, anyways, that was a really long-winded way of saying, I think probably what will end up happening will be off-chain, maybe with some combination of using messages within transactions on-chain.
Okay. And they could certainly comply with the travel rule for on and off ramps between fiat. I think that would be easier to say, oh, us Coinbase, we're sending it to you, TD Bank, here's the details. Like, treat it like a wire. That wouldn't involve changing a whole lot, or would it still create the same problem with their address? But they're going to know the money's coming. If it's going to a bank, it's going in cash form. So Coinbase would have moved it into a cash account. They probably already do that.
Exactly.
So it wouldn't be anything new. And then what about, so they've said also stuff about freezing accounts and things like that. How would that, can they do that with crypto, or?
I mean, if it's a wallet, so if it's my private Bitcoin wallet that I control, no, you can't stop me from transacting, within the Bitcoin network. And Similarly, I could be a sanctioned person. And when I go buy my coffee with cash, there's nothing that's sort of saying I'm a sanctioned person. So you're looking at something similar. But when a transaction is going through one of these intermediaries, there's an expectation that they're doing checking. And so they're checking against the terrorist list. They're checking against the sanctions list, so that they know that the person that they're dealing with, or in some cases the wallet address that they're dealing with, isn't subject to any particular type of sanction or prohibition.
Mm-hmm. And so they said to put mechanisms in place so that say Coinbase, I keep using Coinbase just because I think it's probably the biggest and easiest to recognize, but say Coinbase let a person that's on a sanction list onto their system, which I think Coinbase has pretty strong controls in place already. But if that happened and they found out, or maybe the person got added to the sanction list after they set up their Coinbase account and their ongoing monitoring process alerted them that, okay, this person is someone that is on the sanction list. So Coinbase has recommended then that they should freeze the account, move the funds into a separate account for whatever regulator to come take it. Is that your understanding of it as well?
So I mean, there's always going to be a due process when someone ends up on one of these lists. The type of list, so different lists have different requirements in terms of freezing or not freezing. I would say if you're in doubt, freeze it and get a hold of the right regulatory authority. When we're talking about sanctions, when we're talking about people that are listed terrorists or terrorist entities, they're usually pretty quick to respond. And law enforcement will let you know, like, yes, you need to keep it frozen, or no, this is the wrong, it's not the same person, or there's no specific duty with regards to this list. But if in doubt, I would say definitely, hold on to, like, freeze the asset until you can make that determination. And beyond that, it will really depend in terms of what the reason is for the person or entity being listed, in terms of whether that asset is forfeit or whether there's a process for them to work on getting it back.
Mm-hmm. Mm-hmm. But when we say due process, I don't think it's the same as, they don't get a day in court. If the regulator says that this asset's going to be forfeited, I think they're allowed to just take it. I actually need to learn a little bit more about that, because I know there was a recent Supreme Court decision in the United States that was against asset forfeiture. But I think it doesn't. I think the Bank Secrecy Act's jurisdiction, anything that refers to terrorism, and it kind of trumps the regular laws out there. So I think the ruling that came out about asset forfeiture a few months ago was only pertaining to regular property, not terrorists.
Absolutely, and I think the argument in that case would be more, I should not have been a listed person, or right. I'm not actually this person, or I'm not, this isn't actually the organization that's on the list. Because when you look at the names of organizations that are on terrorist lists, first of all, for individuals, there are a ton of common names. And then when you're talking about names of organizations, there's things that you look at and you're like, okay, that makes sense. It's flaming sword of something or other. And then there's some that you look at where you're like, Carol's Cupcakes. What?
Mm-hmm.
And it's something that's been a front business for a terrorist organization, because it had everyone loved cupcakes. It's such an innocent sounding name, right?
Yeah.
So you do have a mix of these things. And it is possible that the person or the entity is not actually the listed person or entity. And so when I'm talking about due process, that's part of it, where it might be the wrong person. There are situations where maybe someone or an entity should not have been listed. But generally speaking, I didn't mean to suggest that if it is a known terrorist organization that is clearly a terrorist organization, that they get to argue for their funds back. They probably don't.
hmm Now, one thing I haven't seen anything about this, but I was thinking about it myself was, what country gets to keep the forfeited funds? Does it depend on if it happened, if the funds were caught? Maybe they should make it whatever country catches the funds, they get to keep it. So there's some kind of incentive. Not, well, that's a double-edged sword, maybe, but it would be, if it's a large sum of money and it originated in one country and was found in another country, I maybe they split it, or I don't know what is in place for deciding that. But.
Yeah, I think it depends, but if I had to guess, I would guess probably the country that actually does seize the funds would generally keep those, unless they were acting on behalf of law enforcement in another jurisdiction.
Mm-hmm. Or maybe if I were FAFT, I'd say, oh, you got to give us 10% of whatever you seize because we took the time to put these great regulations that helped you catch the terrorists in place. Or who knows how I shouldn't make so light of it. And then, so I guess the other thing, how do you think this will impact the Bitcoin space going forward?
I think that a lot of exchanges and brokerages and other Bitcoin companies have already been operating in a regulated way. Even in the Canadian context, where the regulation isn't in force yet, we've been doing compliance programs for Bitcoin companies since 2013. I know that my sample is very biased, by the way. So if you're not, if you're not interested in doing compliance, you would probably never have had a conversation with me. So I don't know about you, and that's okay too. But we've definitely seen companies that have been operating as if they're regulated because they do want those fiat on-off ramps. That is something that banks have been insisting on. From a U.S. perspective, the U.S. didn't even have a legal change. The U.S. just looked at it and said, no, this is money transfer, so it's going to, it falls under the existing regulation. And that's been in place for a long time, those decisions stateside. I don't think for the most part that it's going to make that much of a difference. I do think that the travel rule is probably the most interesting piece, in that I really hope what comes out of that is international collaboration. And so I hope, based on that countries get together and start talking about what's an effective system to do this travel rule transfer of data, and that there is maybe some sort of public-private, multinational partnership that ends up happening in terms of being able to do that in a way that, that is elegant, that's going to work for the exchanges and help the countries to live up to the policy guidance from the FATF.
Agreed. Yeah. And to safeguard the data too from hackers. That's another big piece of the more data you collect, the more vulnerable it becomes to attacks. So
yeah, I agree with that. Certainly the further we can get away from having an Equifax 2.0 situation, because we've created a big data honeypot, the better I think it is.
Mm-hmm. Mm-hmm. And so what have they recommended for each country to do in terms of oversight?
So for each country, the idea is that the VASPs would be regulated. There would be a regulator that would oversee them to essentially make sure they're doing the things that they're supposed to do. So registering, having a compliance program in place, having a compliance officer, doing training, having regular audits. So from a country's perspective, each country needs to put a regime in place. This was discussed at a recent G20 meeting, and in that meeting, the G20 countries had all agreed that they would enact something within their countries within the next year. So I think for countries that are part of that group that haven't seen regulation come about yet, they will probably see that happening at an accelerated pace.
Mm-hmm. Yeah. And did they make any recommendations for anonymity? What can I say that? For privacy enhanced technology.
So that's a really funny one, isn't it? That when we talk about privacy enhanced, And they actually do say it a little bit differently. So they talk about it as being technology that's pseudonymous, or that allows for anonymity enhanced transactions. And I think that's going to be a little bit of a point of contention between privacy and anti-money laundering. Generally speaking, I do think there's a lot of tension between those two subjects, and there has been from the beginning. There probably will be for the foreseeable future. But that's one of the things when the Financial Action Task Force talks about what makes a VASP risky. So what would make a business more high risk? And they talk about, can you identify the beneficiary of the transaction or not? So do you know who the transaction is really being done on behalf of? Pseudonymous or anonymity enhanced transactions, the absence of face-to-face contact, which is most of crypto, and then the cross-border nature of the business. And so from that perspective, if I'm running a counter where I'm selling Bitcoin to Canadians and you must physically come into my store and give me money or use my point of sale terminal, and then I will transfer Bitcoin to you, then that's a very different type of business than if you're doing an online exchange where you're never meeting with the person, and where you're dealing with customers from all over the world, potentially. Mm-hmm.
Absolutely. And did they mention the unbanked population?
So they do have a mandate within the FATF for financial inclusion. That's part of what they're looking at. The intent of these recommendations is never to inhibit people from being able to use the banking system. I don't think that it plays out really strongly in this set of policy guidance, other than really to say that there should be access to banking for virtual asset service providers.
Mm-hmm. Which that's, we are, like, the VASPs is an unbanked population in large part. So that is really nice that they included that. And yesterday, actually, we saw those tweets from President Trump, quite negative on Bitcoin, saying it's only used for illicit activity and has no value. And then we see Mnuchin come on yesterday. He's the U.S. Secretary Treasury, and he said kind of the same thing. At first, he was really focused on the ability of drug dealers and other, terrorists to use Bitcoin as a big part of their scheme. And then he went on to say, if you're using it within the confines of our banking system, then that's completely fine. So I think between all of this, it's what I see mostly is people coming in that want to use this technology for business purpose. And yes, a lot of the Bitcoin, OGs really like it for the privacy purposes, and those, like you said, are at odds. But there is at least now a path where it seems like it will be easier to get bank accounts. It will be, there's guidance for the rest of the world. I know a lot of, America already had it, but there is now a really quite clear path of how to do this. If you want to issue a new token, you can do it through some regulated crowdfunding, make a security token. If you want to do a proof of work coin, we know the guidance of what is a security, what's not a security, what is a service provider. The fact that every crypto to crypto transaction is covered in this, we know it from a tax perspective. I just feel like all the regulations are kind of rounding out, so there's a lot less guesswork to it. And overall, I appreciate that. I'm sure, you do too. And it just makes doing things a lot easier. And a lot of people that I come across that are new to the business or something like that, they still think that there might not be, that it's the Wild West, but it's really not anymore. And there's a very clear process of how to interact inside these laws and create successful companies. So all in all, I think maybe some people disagree, but I think the more clarity we get on these issues, the better, and the more safe they can make it for users, the better, because we don't want more exchanges continually failing or more, fraudsters taking people's money, because I think that overall hurts the growth and adoption for Bitcoin. So
Yeah, I agree with that. I think the more that we can do around safety and soundness, the better that is. The more that we have non-custodial products, so hot wallets, cold wallets, all of the above, that have a really good user experience, that allow people to self-custody and transact in a way that's peer-to-peer, but to be sovereign over their own assets, I think that's a really good thing.
And it's really nice that they haven't attacked that with regulation. Attack might not be the right word, but that is allowed to exist outside of a lot of this regulation, because had they come out and said, any transaction, whether it's self-custody or not, like putting that custody distinction in there is what really allows Bitcoin to keep flourishing, I think. And more growth will work. People are going to be developing, that's going to be a key feature that most new projects are probably going to look at, is the self-custody.
I agree. And in a sense, I think that one of the good parts of these recommendations is that technology service providers are really going to be forced to consider how they build. And they're going to have to decide, do I want to be a technology service provider where I'm giving people the tools to do what they need and they're self-custodying? Or do I want to be a virtual asset service provider where I'm doing custody on behalf of my customer? And I think that we are going to end up, hopefully, this might be pathologically optimistic, but with some much sexier front-end user experiences, because you have companies that are motivated to develop things that allow people to self-custody because they don't want to be in the custodian position. And I think that's good. We need those tools. So if you're developing them.
Yes, good job. All right, Amber, well, thank you so much. This was really enlightening about the ins and outs of these upcoming regulations. And where can people find you?
So I'm at outliercanada.com or Outlier Canada on Twitter.
Okay, sounds good. And are you any upcoming events you're going to be at, or?
So we have our regular meetup coming up next week where we're talking about regulatory changes in Canada. Internationally, we're going to be at Baltic Honey Badger in Latvia again this year.
Oh, very nice. Awesome. I wish I could make it there, but not this year. Anyway, all right. Well, thank you so much. Really appreciate it, and look forward to talking with you soon. Thanks.
Thanks for having me.
Bye.
Bye.
Stop recording.